Welcome back. Okay, last time we finished with the statement of the facts. We're now on to the points on appeal, so let's get going. Points on appeal. In this appeal, defendant appellant presents the following points of error. Points of error are required for the appeals court to make a reversal, some sort of judgment in your favor. Dig into that, learn what it means, learn where it applies. So, Section 1. Defendant appellant was not charged within a statute of limitations, and therefore the alleged offenses were time-barred. Just about all you have heard of the statute of limitations. Many don't know quite how it works. It's spelled out in the statutes. I'll get to that once I get to doing a video on one of my other filings. It was a filing for the day of the actual trial so that I had everything on record and didn't get cut off or misdirected by the judge and prosecutor. Part 2. The first trial court. Judge Harry Freitas erred in conducting and establishing a prima facie case, and by not finding that, as a matter of law, the prosecution had failed to comply with the requirements of process for initiating a criminal case that caused harmful effects and injustice to the defendant appellant. This issue right here you can find in case law. So a lot went into this. I'm giving you guys a shortcut here to look at this stuff. You can just take what I have here and use it to do your research on to make sure that everything appears to check out. You should do this with anybody. Okay. Judge Uterbeck erred by ordering the defendant appellant to a bench trial without conducting a probable cause hearing to determine if the warrantless seizure of defendant appellant by Officer Clarence Davies was lawful, and also without conducting an arraignment hearing or obtaining the knowing waiver of said hearing by defendant. Okay, you can waive the arraignment hearing. You can waive it. Now, you're going to hear people out there that will tell you never ever waive anything. These are the people that don't understand strategy and tactics. By and large, you're probably not going to want to waive certain things. I might or might not go into the details of when and where it's actually beneficial to waive this. I'll just say this much. If you study their procedures, the things that they're supposed to be doing, the things that the judge is required to do, the prosecution, and the witness, if you study what they're supposed to be doing and you find things that they're not doing, and those things happen to be things that would be errors that could be reversed by an appeals court, let's just say maybe you go ahead and waive certain things and you let their errors stand there. Well, you can call them out on the day of the trial, or you can call them out shortly after. And when it goes up to the appeals level, preferably you call them out day of the trial, no later. There's standards for how they evaluate these things based on whether or not issues are raised before or after trial. But if you waive certain things, you can actually wind up benefiting in certain cases because they might be time barred from going back and correcting things that they failed to do by a certain time. So don't listen to people that tell you never ever waive anything. First, study the rules, know them inside and out, know how they typically operate, what they typically do, and from there you can try to make a good game plan. Alright, so number 4. Excuse me. Judge Freitas and Uterbeck erred by failing to acknowledge that only a licensed prosecutor may initiate prosecution for a criminal case, and a police officer is not a prosecuting officer. This is a due process violation. Alright, that alone is reversible. Each one of these things that I raise is a point of error that could be reversed. Okay, then the last two are the same. It's just coming down to bias issues. Totality of the actions by Judge Harry Freitas present clear bias and prejudice that prevented defendant appellant from having fair proceedings and a fair trial. Okay, you know, he was the one that started it. Basically, I wound up being ordered to make 20 appearances before legitimate charges were entered, and they were done about 2 years after the statute of limitations ran. Okay, and with Udovic, I have videos posted showing that he lied about reading a motion to dismiss, and he denied it. And then, what else? Oh, he, in one hearing, was signaling for the prosecutor to make objections, and then at some point he couldn't control himself. He lacked the frontal lobe control necessary to sit there and behave like a good judge. And he jumped in and started entering objections for her. So, yeah, I mean, if that's not biased, I don't know what is. So, that's the points that I'm raising. You see, it's like about 3/4 of a page. It's not a lot. It's dense. It's actually dense. The issues are dense. But these are the sort of things that you want to try to identify here. And again, you know, if they were biased, hopefully you filed a motion to recuse and you laid out the facts as to why they were biased, not an emotional argument, but something like, in my case, having the judge ignore you, enter objections. That's, you know, especially reasonable objections. You know, if something's past the statute of limitations, everybody knows about that. Alright, let's try to get some more done here. Standard of review. Standard of review is there's a standard that the appellate court may apply when dealing with various questions. So in a prior section where I told you sometimes you want to raise issues before trial has ended, because if you do that, there's one standard. It's actually typically more in your favor that will be applied. Whereas if a ruling has already, judgment has come down, they will tend to lean towards the judgment more, unless it's some sort of egregious error, something that affects your substantive rights. Okay, an appellate court may freely review conclusions of law, and the application or applicable standard of review is the right-wrong test. And this is a Hawaii site, so, you know, when you do this for your state, you want to find the standard of review for your situation and have at least a single case site. Let them know that you know what they're supposed to be doing. All right, whether an indictment or a complaint sets forth all the essential elements of a charged offense is a question of law, which we review under the de novo or right-wrong standard. Again, we have a couple Hawaii sites here. Excuse me. Okay, questions presented. Whether defendant appellant was not charged within the statute of limitations, and therefore the alleged offenses were time barred. Whether the first trial court, Judge Harry Freitas, erred in conducting and establishing a prima facie case, and by not finding that, as a matter of law, the prosecution had failed to comply with the requirements of process for initiating a criminal case that caused harmful effects and injustice to the defendant appellant. Whether Judge Udovic erred by ordering defendant appellant to a bench trial without conducting a probable cause hearing to determine if the warrantless seizure of defendant appellant by Officer Clarence Davies was lawful, and also without conducting an arraignment hearing or obtaining the knowing waiver of said hearing by defendant appellant. Whether Judge Freitas and Udovic erred by failing to acknowledge that only a licensed prosecutor may initiate prosecution for a criminal case, and a police officer is not a prosecuting officer. Was this a due process violation? Whether totality of the actions by Judge Harry Freitas present clear bias and prejudice that prevented defendant appellant from having fair proceedings and a fair trial. And lastly, whether the totality of the actions by Judge Michael Udovic present clear bias and prejudice that prevented defendant appellant from having fair proceedings.